Let's start with the Supreme Court. So I guess this was 2 days ago now. Supreme Court was looking at a case, Bucklew versus Presseth. I don't know who Presseth is. Probably somebody associated with a prison, or and it was a case involving a guy who was on death row. This guy, Russell Bucklew, he committed a brutal murder in 1996. He was sentenced to die. And the guy has what is known as cavernous hemorrhagia. It's a disease which causes basically tumors to grow around your head and your neck and your throat. And this guy, Bucklew, was going to be killed by the state of Missouri. And they wanted to give him a shot of lethal dose of barbiturate pentobarbital. I don't know what the name of it is. And however, Bucklew is afraid that the drug is going to cause him to essentially choke on his own tumors, causing him extreme pain and suffering in the last minutes before he dies. And most of this stuff is I'm reading from Ian Millhiser, who writes for I think this Think Progress is legal. He's the legal editor over there. And so the idea is that, the Eighth Amendment to the Constitution says that you could not have punishment that involves cruel and unusual punishment. And this guy, Bucklew, is arguing that, well, it is cruel, in particular, to kill me in such a way that I'm going to suffer dramatically at my death. And for literally decades, the way that the Supreme Court has viewed the idea of cruel and unusual is that cruel, obviously, or I should say unusual, implies that a particular punishment has become less and less common. Right? And as it becomes less and less common, because people just become repulsed by it, it actually becomes, its constitutional foundations become weaker. So there is this concept, as Justice Earl Warren explained in 1958, that the Eighth Amendment prohibits punishments that defy, quote, evolving standards of decency that mark the progress of a maturing society. So back in the day, right, like 1500, you were going to kill somebody. One of the ways they would do it is they would cut your stomach open. They, tie you down, cut your stomach open, let your entrails come out.
It was a tough deal.
And that was just the way that we kill people. And then maybe we chop their head off.
An eye for an eye.
Over time, however, we found that kind of punishment to be grotesque and overly cruel. And apparently, this standard has been tossed by Gorsuch in favor of a standard that the unusual measure is pegged to the time of the framing of the Constitution. What? So Gorsuch was talking about punishments that would have been forbidden at the time of the framing. Quote, these included such disgusting practices as dragging the prisoner to the place of the execution, disemboweling, quartering, public dissection, burning alive, all of which Blackstone, he's referring to another judge, savored of torture or cruelty. He adds that by the time of the founding, these methods had long fallen out of use and so had become unusual. So unusual is not an evolving standard. It is one that is pegged to basically 200 some odd years ago.
That is actually originalism in a nutshell. That's one of the reasons it's such an incredibly fraudulent, doltish way of reading the Constitution.
You're going to put him up a little bit. I can't.
That's.
Are you talking into the microphone?
Yeah, absolutely. That's originalism.
Okay, yeah, there we go.
That's originalism is a structural problem. I mean, that's their standard for everything.
Yes. And so he defines the word unusual to mean punishments that had long fallen out of use at the time of the founding, not punishments that are uncommon today. So this evolving standards of decency in the context of the Eighth Amendment has been thrown out. And the definition of cruelty for this guy has also changed under a case in 2015 called the Glossop v. Gross case. Because that case determined that the death penalty enjoys some form, according to Ian Millhiser, of super legal status that protects it even from private citizens who refuse to be complicit in executions. Glossop, and I think people might remember this, is when there were drug manufacturers who decided that the drugs that they were selling, which weren't developed necessarily to kill people, refused to sell those drugs to states that wanted to use them to kill people. And so what happened is that some states turned to other drugs, painkillers of questionable reliability, which, according to Elena Kagan, writes Millhiser, left death row inmates with the feeling of being burned alive. And that because that was the case, that was a torturous death and amounted to being cruel. At the time, the conservative majority, Sam Alito, who wrote the Glossop opinion, dismissed the drug company's refusal to be complicit in executions as a guerrilla war against the death penalty. And he held that because it is settled that the capital punishment is constitutional, it necessarily means that the way of that the idea of executing people, there must be a constitutional way in which to do it. In other words, if it's constitutional to kill people, the means in which you kill people must also be constitutional, or at least one must exist. And so if there's only one option to kill people, and even if it happens to be super painful, that is not enough to prevent the execution. So the idea is, and in this instance, the burden at that point falls upon, if you can believe this, the prisoner and their lawyer to come up with another way in which they can be killed. And there's even a greater burden because this guy in Bucklew said, okay, well, I have another idea. You can asphyxiate me with nitrogen gas. Put me in a room, pour some nitrogen gas in there, I'll die. According to Gorsuch, that's not enough. You got to come up with a plan that describes how we can protect the people who administer it, that we can protect the you got to come up with the whole thing.
You need to redesign the prison, all right?
Death row inmates must not only tell the courts how they wish to be killed, they must offer a proposal that is, quote, sufficiently detailed to permit a finding that the state could carry it out relatively easy and relatively quickly.
So he's just a sadist.
Well, but here's the thing. Oh yeah, no, he's a sadist. So that is basically a slight sideshow. It does not give prisoners a very easy way, essentially, to come up with an alternative that's not going to be super painful. So the bar in which you can suggest some other way has been raised to where you can't just suggest another way that you want to be killed. You got to suggest another way to be killed that will make it easy for the state and safe for the state. And you need to have that proposal really drawn out. So in the absence of that, you can be killed in a way that is extremely painful because A, the definition of unusual really only pertains to things that were unusual 200 years ago, 250. And the definition of cruel now is not something that is cruel, de facto cruel. It'll cause you a ton of pain, yes. But that's not the legal standard for what is cruel, according to the Supreme Court now. The legal standard for cruel is if the intent is to cause you a lot of pain.
Yes, and the intent will be, as ever, undeterminable.
Well,
and even if we had brain imaging software to prove somebody's intent, we couldn't use it because that wasn't accounted for 200 years ago when the Constitution was written.
No, no.
How would you do that?
How would you? This is how the court would determine that the intent is to make you to be cruel.
If somebody wrote it,
if you, as a someone on death row, wrote out with your lawyer an extremely detailed plan with schematics and how this you were going to be killed by using some type of nitrogen gas that was going to make it perfectly safe for everybody and would involve no risk, would be super easy, not too prohibitively expensive. And then the state said, no, we're not going to do that. We're just going to do the one that's going to cause you a tremendous amount of cruel.
It was all specced out. That really speaks poorly of you.
That's how you would prove that intent.
Could you not argue that having a prisoner write the sort of specific details and logistics of how they're going to be killed is a form of torture in and of itself?
No,
I mean,
you could argue that, but no, you would not have a hearing at the Supreme Court.
Right, but you would be
what kind of circular logic is that to say that cruel and unusual punishment is constitutional because killing people is constitutional?
Well, that is that's the way that they work.
It doesn't make any sense. Although I guess, killing people in and of itself is cruel and unusual. So in that sense, they might be right.
They have not found that that the actual act of capital punishment is cruel and unusual. Then they're just assessing the means in which you do it. So understand, though, what this means. Aside from it meaning, and there have been less and less executions as we evolve, mostly in non-red states. A couple of blue states, I think, still have it. But as we evolve as a species and decide that the state should not be permitted to execute people in cold blood, and I'm happy to have this debate about capital punishment, but that's aside. The import of this is not only that we can do this in a what any normal human being would consider cruel and unusual in terms of the of killing people, but that this group on the Supreme Court, as is constituted now, these 5 have no problem overturning 50 years of precedent. 60, really. And they're not terribly explicit about it. In other words, they're not saying we're overturning this precedent because we found it to be X, Y, or Z. They are just reinterpreting things like unusual, reinterpreting things like cruel.
Well, this position allows you to be the ultimate judicial activist because if everything that is written at the time of the founding is essentially illegitimate, then actually that gives you an incredible amount of room to hack away at a couple hundred years of legal work.
I mean,
without any intellectual coherence or rigor. And this whole thing, people really should look at even, as distinct from like the PR and the communications aspects, but like the origins of things like the Federalist Society as like these august academic projects are just another arm of PR machinery. It's like it's fake law to not only against like evolving standards liberal law, but against even common law. So established
we're
precedent.
lucky that there's an amendment abolishing slavery except as a punishment, or they would probably try to bring that back too.
Right. Well, it's still there for prisoners. You can still do it according to the 13th Amendment.